I will do some quick introductions. I think many of you know me, but my name is Manatt Stevens. I am the owner of the Essen Company and currently the AMA president. And I'm joined by Mary Dale, who is the owner and creative director of Big Leo and the business affairs director of our board and the head of our legislative committee. Also with us is Jim Walsh from Manatt. He is our lead counsel and lobbyist in this effort. And with him is Laura Manlin-Ladopoulos, senior legislative analyst, also with Manatt. So we also have a bunch of other current and former founding board members with us who deserve a lot of thanks and for all their efforts in this previously and now, and also just with the AMA in general. Everybody puts in a lot of work. Our call today is to give you, our members, and some other folks joining us, an update on our advocacy in relation to the New York State Fashion Workers Act. And we wanted to give you an opportunity to ask questions of us and also of Jim and Laura. So many of you, I think, are aware of the bill, but for those who are not so familiar with it, I was going to give a little bit of background. It was introduced last year, about this time or a little earlier, by Senator Hoylman Segal and Assemblymember Reyes at the suggestion of Sarah Ziff of the Model Alliance. There was no outreach that we're aware of to any of us at the AMA or to any creatives or creative representation agencies before the bill's introduction. It's our understanding, like we believe that creatives were included in this bill based on 2 phone calls made to the Model Alliance hotline by creatives who were unhappy for non-payment or unhappy with their agents. So from all of our outreach and conversations over the past year, it's very clear to us that this inclusion of us in the bill was not something that was requested by creatives in the industry at large. So we think that we were added as an afterthought to help them gain momentum, when in fact, I think it's really gonna curtail their efforts quite a lot. The bill's stated intention is to close the legal loophole by which management companies escape accountability and create basic protections for fashion's creative workforce. So, that may sound reasonable to those outside of our industry, and it is a valid concern for, in regard to inexperienced models, but it is a really flawed statement in relation to our creatives and our creative management companies who ended up included in this bill. So we learned of the bill in May of 2022. It was first brought to our attention by Emily Pitts, who I think might be with us. And we had already had a scheduled meeting with Sarah Ziff for the following week, which I was not in attendance, but we had. She was not engaging on this topic with us. I think once she realized we weren't on the call to congratulate her for this, it was a very short conversation, and she has since not reached back out or gotten back in touch with us, despite the fact that we've reached out. We moved quickly in the spring. We hired Manatt by the last week in May, so that we would have immediate representation in Albany and could start conversations. So the bill passed the Labor Committee at the time, but did not get any farther, and that was largely due to our efforts at the time. The Senate adjourned in early June, and we spent the summer and early fall really going through the bill, like line by line, and drafting a full response to the points so that we were prepared to start calls again in the fall when the legislators were back in session. We listened to concerns expressed by many of you last year at the town hall. We've had many conversations over these months with some of you and with others in the industry. And we have focused our attention on really the unintended and negative consequences of this bill. And we have been really intent on educating the legislators and making sure that they understand the nuances of our industry, which most of them, not surprisingly, do not know. And so there's been a very kind of clear focus for us on making sure they understand what it is they're reading in this bill and why we have issues with it. So Mary joined the board in October, and that was right when our meetings began to kick off. So she and I have done a lot of them together with Jim and with Laura. So I'm going to let Mary talk to you about some of the substance of those calls and some of the points that we have been making these past few months.
Thank you, Vanessa. Yeah, I'd like to just give a little bit of an overview of our call strategy. To date, we have had dozens of calls with New York legislators, and these calls have been integral to voicing our concerns as well as our opposition, but also, as Vanessa said, in explaining how our industry works in general. They really don't understand just the whole pipeline of how things work in our industry, including payment terms. And that's what resonates with them most, is the payment term concerns that we have with our own clients. So we stress first and foremost, because this is a labor bill, that we are not against worker protections, but that in fact our principles align with worker protections. And as agents, we ourselves are artist advocates, helping them negotiate fair and industry standard rates, their usages, licensing terms, and much more. Won't get into that. We do a lot for our artists, but on our calls, we provide some background on the bill if there isn't familiarity with it. Some people aren't sponsors and might not be as familiar with this specific bill. And then we explain our specific issues therein. We also explain our industry, its nuances, the procurement processes, because many of these legislators, like I said, aren't familiar with the pipeline, how these projects come to us, or any of it. We explain that the creatives with whom we work and represent are seasoned professionals who tend to seek us out, that they are business professionals, many of whom have their own LLCs, corporate structures, sometimes even with their own employees. We talk about how, by and large, our membership, artist management companies, are minority and women-owned businesses, small businesses who will be unduly burdened by some of the requirements within this bill, and in some cases shuttered by some of the others, such as payment requirements and the fines for noncompliance and more. We then express the impossibility for us to pay our creatives before we are paid. This suggests that more than we already do, we should finance these productions on behalf of major corporations, and barring the advances we secure, pay even creative fees before jobs have been fully wrapped and invoiced and paid. And I know even here today, there are many single agents out there, but this would greatly impair, if not irreparably harm, even some of the larger agencies. We explain the process of wrapping jobs, how with larger productions, this could take up to a month, and that our clients' payment terms kick in when they receive that invoice, not from the last day of our productions. And most importantly, that we have no enforceability for the payment terms as laid out in this bill, as they align with the current payment terms from our clients. I'm sure we'd all love to be paid within 30 days versus 60 or 90 or even 120, but we don't have any way to enforce that. So the goal of these calls has been to evidence how this bill has currently written, will do more harm than good if passed, and therefore serious redrafting is needed for us to consider supporting it. We follow up after these calls, sending our memo of opposition, and we ask each legislator to talk to the sponsors, Hoylman and Sigal and Reyes, to staff, and to committee members about the harm this will do to creatives, to our businesses, to the massive number of workers in New York who support this industry, and to the city and state if this passes. There are, oh, go ahead.
Sorry, I was going to say, a lot of this is probably very obvious to many of you because you are in our shoes, but the whole point of these conversations is that the legislators do not know this, and they're blindly signing on to this bill because at face value, the idea of protecting workers sounds great and we align with it. So like, we're just giving you an update.
This is a recap of how we're kind of having to robustly explain what we do and what we're up against. So there are many provisions in the bill that we have issues with, and many that just simply do not relate to creatives, but our focus has been on the big picture issues that easily resonate with them. And we feel that we've been successful in demonstrating the flaws in this one-size-fits-all approach to the bill. So our strategy has been to work on coalition building within the industry with the 4As, the ANA, the AICP, the APA, and conversations with legislators in Albany. So I'd love to turn it over to Jim to talk a little bit about that process and next steps for us. Jim is there.
Yeah, I was trying to unmute, and maybe Jen had to do that for me. Good to see everyone, and thanks for participating, and thanks for bringing us on board on behalf of the Artist Management Association. I think both Vanessa and Mary have aptly described really what our effort has been to date. Again, we had to react quickly last May to try and stop the bill, raise enough issues and concerns, which we're grateful the legislature understood that this bill wasn't as simplistic as it purported to be, that the potential impacts were potentially far greater than maybe the Model Alliance and others had described to them. But it also meant we had a lot of work to do, as again, Vanessa and Mary have described, in helping the legislature understand an industry for which virtually all of them or none of them have ever been exposed. They were probably very unfamiliar with what a production is, all the people involved in a production, the processes involved. And, you know, the legislature's job is to legislate, and that's what we were up against. It is to pass bills for people to get all the credit for implementing law that will affect lots of people, presumably in a favorable way. So the process is geared towards that. It's important, therefore, that organizations like AMA, when they're made aware of potential negative impacts, that their voice is heard as well. And so our strategy really has been focused on sending that message. This bill, while laudable in its intent, has many deficiencies, unintended consequences, and that's what we have targeted our communications towards, you know, legislators who principally are on the labor committees. The bill is in the labor committee in both houses because they've never heard this story. They think worker protections, that's great. So this was really our opportunity to share with them. Yes, but there's another side to this. If you push, you know, the protectors out of the industry, and I view our artist managers, our artist management companies as the protectors out of the industry, which this bill could do and would do, those workers are actually more vulnerable than they were before the legislation, if it were to be enacted into law. We did start meetings really going back to last May. We calibrated our messaging over the summer and in earnest began another round of meetings with senators and assembly members and staff people in the fall. We've had 18 meetings since we reinvigorated that effort, again, mostly targeted towards labor committee members, and all with that message, which Mary described. You know, here's why you legislators should be concerned about a bill like this. It's not what it purports to be. Please talk to the sponsors, let them know these are real concerns. And the point being, there's we certainly don't believe that creatives and creative managers and management companies belong in this bill. That could be a different conversation to think about how we might protect creatives and as well as creative managers, frankly, in the larger context of the productions and advertising efforts that you undertake. But this bill is not that vehicle. And we've had very favorable reaction from many legislators, as I think was shared with you. But in terms of process, we're at the you know, the midpoint of April. Session is supposed to go until it'll probably go roughly into June 8th, 9th, 10th, 12th, something like that, depending on how long the legislature wants to stay in. And that's a long time for the legislature to pass more bills. They pass probably 3/4 of the bills that they will pass in a session, which began in January. They'll pass 3/4 of those bills in the last 3-4 weeks. And for that reason, this is really a high point for us. All that work we've been doing beforehand, this is the culmination of that effort to continue to have those conversations with legislators, with staff, and urge them to talk to the sponsors, talk to the Senate and Assembly leadership, and stop these bills or have them amended so we are ultimately removed. We have issued or reissued a memo in opposition by the Artist Management Association. We are coordinating with a number of other interests, as Mary described, to also have them alerted to the impact upon their industries, and especially where it coincides with the impacts to our industry, why, again, we should have a resolution that's addresses our issues. I don't know if
one other thing you told me, Jim, which I thought was relevant, is that no significant amendments were made to the bill, but also no other sponsors have joined on, which I believe is significant as well.
Yeah, so let me thank you for the reminder on that, Vanessa. So, what you often see in the legislative process is other legislators who see a bill and they're like, oh, that sounds like a great idea. I want to support that. But I believe because of our outreach, the sponsors who were on the bill from the very first day it was introduced in 2022 remain the only sponsors. And that's the principal sponsors, again, Senator Brad Hoylman-Sigal, and Senator Robert Jackson, who represents the Harlem area, and in the Assembly member Karina Reyes, who represents the Bronx, is joined by one additional sponsor, Dr. Anna Kellis, who's from Ithaca. And so using that as a measure, we've been pretty effective because usually you have a lot more sponsors around by the time a bill has been around for a year or so, which this one has. So we've been pretty pleased by that fact. What was the second point, Vanessa? I've already forgotten as I focused on
that that it was reintroduced, but with no significant amendments, which was really just like page numbers or something.
Yeah, so we had again urged going back to last year that the Senate in particular should amend the bill because Senator Sigal is really the moving force for this. He seems to be the most engaged with the Model Alliance, and we've been urging his staff and he to take us out of the bill. We are aware that some of the model managers had also been engaged with him about amending the bill to make it less impactful to them and some of the unique elements of their industry. Unfortunately, when Senator Hoylman-Sigal reintroduced this bill in January, no substantive changes were made to the bill. The only changes were, again, some dates, some numbers referencing the sections and so on. So nothing substantive. That may be because they're going to do any amendments all at one time. They're not going to do them piecemeal. But it also means we think if we're going to see amendments, there'll be sometime in May, maybe later in May if the Senate in particular intends to pass the bill. Our effort, again, is geared towards making sure that those amendments reflect changes we want to see, or frankly, that the bill gets held due to opposition.
I don't know if anyone has any specific questions. We're happy to try to answer them. Process or otherwise. So I think back in last spring, we did a big push for people to reach out to their specific senators and to the sponsors specifically. So if you did that, thank you. But now is when actually it would be a very impactful moment to do it again. So on the website, we have updated slightly based on our, all of our conversations and what seems to be resonating. We've updated the call and email scripts. I think Jen just put that in the chat. And, we did, again, recently reach out to Sarah. We have not heard back. We're more than happy and willing and would love the opportunity to talk to her to understand sort of why, from her perspective, it's so important to have us in. We've been following the press that she's putting out there, and it is 99% about models. So it feels like there should be really plenty of room for a conversation about us being removed. We yesterday spoke with the Freelancers Union, and we have Meredith Tanner from the Freelancers Union on the call listening in. She's their policy director. And, Meredith, I don't want to speak for you or put you on the spot, but it seemed as though they were really quite understanding in our concerns and were willing to really give it another thought and speak with the sponsors about our concerns as well. So, while our current focus is really on amendments, we're also not opposed to the idea of holding it or having it simply go away, because that's an option. There are a lot of amendments we would need to be implemented, and we have a lot of those talking points at hand and ready to go for the conversations that we have and will have. Mary and I are most likely going to Albany in early May to have meetings in person with Jim and with Laura. And if anybody wants to join us, you're more than welcome to come. I think we might have the APA joining us, which would be an incredibly impactful message as they represent the creatives themselves. In some of the conversations we have, there's this assumption that our issues are purely for ourselves as the managers. And while we are concerned for ourselves and our businesses and our employees, we really recognize the massive negative implications this has on artists themselves. So the bill, part of the way it's written, it defines a client as a photographer, is defined as both a client and a creative, which is complicated and confusing. But the simple fact is, if you're an unrepresented photographer, you become the client in the situation, and you would have to pay your team before potentially you're paid by your client. And that's a huge burden to put on a single freelance photographer. So we also don't want that burden on us, because we're not banks and can't float this money, but we really recognize that this is a huge issue for individual artists, and we're fighting that for them. I guess the other note is really the continuation of our work with other trade organizations like APA. We are more than happy to have input from all of you for other people that we can be in communication with and other outreach we could be doing that would help further this. So please, separately or now, or whatever, reach out, let us know any thoughts on how to get this message beyond simply our organization, because it will affect a lot of people, producers, everyone working, anybody who holds this definition as a client in this bill. And if we decide as agents or as artist representatives that we're not going to be paying people, we're still affected by it, but we can pass a lot of the burden on to other people, and therefore they're not going to be very happy about that. So again, we're happy for any thoughts if anybody has a question.
Vanessa, can I just add our strategy, and again, it isn't to undermine reasonable worker protections, but this bill is not it. Is to raise our concerns, and we principally are doing that through a number of vehicles. We have issued our memo in opposition to all of the legislators in the New York State Legislature, both the State Senate and the State Assembly. We're organizing other like-minded organizations, alerting them to this bill, and have been doing that. And fortunately, that is paying dividends now, because the legislature should hear from those interests as well. And again, most often they're aligning with many of the arguments we're making. Some may have unique arguments, and that's fine. And so we think it's important that the legislature hear from those folks as well. And that that other piece is, the legislators should hear from constituents, and that's all of you and your colleagues, the people you work with, who will argue and present hey, here's why I'm concerned. This is what it means to me. And we fortunately prepared a draft of that email. And there's an email, every legislator has an email address. Send it to those who, represent where you live or where you work or both. Or you could send them to Senator Hoylman Seagull and Assemblymember Reyes. Though anytime you can make those communications, legislators are elected by constituents, by the people. And when they hear from enough people, they realize, this might be a problem. I should take a closer look at it. So I just wanted to emphasize that point. We're trying to be as effective as we can in Albany, and certainly through the great work of Vanessa and Mary and Jen. But there's a larger role for what we refer to as the grassroots to have their communications and to be heard.
One other thing I think is important to call out about this bill, and another reason why it's so poorly written. It's incredibly vague on a number of topics, but one of them that's pretty clear is, it's called the New York Fashion Workers Act. Actually, I'm going to make 2 points about this. One is that it affects many more of us than are just doing, actually operating out of New York. If you do business in New York, if you have an artist who does, if you have a production that does, if you have a client that does, it will affect you. So while from a city and state perspective, the loss of income and the loss of local jobs is huge, it has a very, very big ripple effect beyond simply New York and New York State. So as a rallying cry, for those of you or can reach out to colleagues outside the city, it's still very relevant. The other issue is, again, with its title, it's called the New York Fashion Workers Act, but the way it describes creatives and artists, it means anybody working on set with a model, which, as we know, goes beyond purely the definition of fashion. So, Mary, for example, doesn't work in fashion the way that some of us do. But she works with models, and therefore, so many of us who work in a much more commercial realm are still completely affected by this. And I think that's something else that might be helpful as you reach out to other people who aren't on this call to explain the issues. It's just got giant ripple effects that go beyond what it initially intended to do. And I think that there are, again, this isn't really our area, but there are aspects of the fashion world in New York that don't relate to us as people producing photo shoots, but simply relate to touching on models and, not touching on, but, working with models. So it's just badly written. It's vague and it's confusing and needs a lot of work to be something that's worth passing.
Vanessa, I assume that that there's a coalition of model managers that are making an effort and have hired a lobbyist by the name of Deborah Feinberg to make amendments to the bill.
Yes.
We feel if we don't want to throw the bill out, but we want to shape it so it agrees that it works for us. Whereas you explained it really doesn't work for us. So if we could really coordinate a lot of this stuff, we're becoming very active. I think we waited a little too long, but we have now been very active to try to change or amend this bill. And I was just wondering if you're aware of all that.
Yes, Jim, do you want to talk a little bit about that?
Sure. So, I'm very familiar with Deborah Feinberg, and she and I have spoken, and we do compare notes periodically, which has been great. The challenge we face is we represent two very different interests. And so the strategy being pursued by the model managers is reasonable under the circumstances. Again, they believe, we believe, I think most people would believe the bill really is targeted at that industry. Whereas just reading the bill, it became pretty apparent creatives were thrown in as an afterthought, and we don't think it's a good match. So our ask, if you will, of the legislature is a little different. We're not prepared to seek amendments to fix the bill on, regarding subparagraph B. Our fundamental ask is take us out of the bill. And if you don't take us out of the bill, then the bill should not pass.
But Joey, to your point, we are aware, and we're not opposed to working towards, when basically we would like our goal to be met. And then once that is met, working to make sure that it does work and does not further harm the industry is an important role that we need to play, because many of the ways that it is, that it's written could actually just push business out of the city and out of the state in a way that we don't want. So we're aware of that, and we're happy to be part of that conversation. We have to get past our main hurdle first, because that's what we need to do for our membership.
We're not opposed to having the whole bill thrown out. That's for sure. I mean, that would be our main goal. But if we had to live with it, at least listen to what our concerns are and make adjustments to it.
Mm-hmm. Yeah.
But I'm glad. So I'm glad we can all work together for the betterment of the industry.
Yes, I think that there are definitely issues that can be addressed. They just have to be addressed correctly so that it doesn't end up backfiring dramatically. And actually, the real interest here is protecting people. And as it's currently drafted, it would not do that really in any substantive way.
And we don't want it to be an all or nothing situation for the models. We value what they're trying to do for model protections. We talk about that ad nauseum, wanting it to be, a really dense and great bill for them, but with us in it, it's just not something we can support.
Over the years, I always felt as a manager and as an agent, we were the protectors of the models. We were the ones who decided how many people were on set when there was when there was a lingerie set, a lingerie shoot, when there were nude shoots, how many were allowed to be there, and the cover-ups and the times and the so we were always looking out for the protection and the betterment of the model in the industry, over time, and negotiating their rates. And so for this bill to come in and say they're protecting, we've been doing it for as long as I've been in the business. And that's why we
do get a lot of comments about, or even from the freelancers union, bringing up bad actors. And I mean, I think that's unavoidable in any situation on earth. There's always going to be bad actors, but this is really an overreach for a few. I mean, in my 20 years, I can think of one agent I've heard any rumblings about that has done something bad. Maybe some of you have heard more, but it's certainly not pervasive. And to your point, we're the protectors. We're here to advocate for the artists and their rights.
And a scam artist, as soon as they open up or do an advertisement, right away. But the people who've been in the industry for years and years, who've got a reputation and uphold it.
Yeah,
that's fair.
Yeah,
but we just the opposition. Oh, I'm sorry.
Go ahead.
Do you have the opposition letter that you give to the legislators? Can we have
it's on the website? Yep.
Okay.
And Jen put a link in the chat. And if anybody does want to reach out directly to any of the legislators and wants some more specific talking points, we're happy to jump on a call and really work on something that feels personal to the issues that you or your artists might be having. Because we haven't gone through all the issues, but there are a lot of points in the bill that just feel completely out of place. Of course, the payment terms are the big one. The commission caps on photography are a big one. It will force so many people, so many of us as representatives, to offer less to our artists and put them in a position where they're going to have to pay out of pocket. And there are, there's, contracts that would have to be approved by the Labor Department. There's the need to annually, re-sign artists, and there's like time that if your artist doesn't work, that they automatically it voids the contract. They're just like very specific issues that are problematic. And depending on who we're speaking to on our calls, we can get into details because people are interested in those things. But we're certainly prepared to talk them through with any of you if you'd like. So yeah, does anyone else want to have a question?
Or anything to add?
Not on my end.
Well, we do continue to need and want support from all of you in this effort. Jim is great, but he's not cheap, and we need to keep this going. So if any of you are not members, please join. If you're not a partner and you're interested in being a partner, you can talk to Jen. If you're not, you can't fit in to be either one of those things and you still want to contribute, we would happily take some donations for this effort. Also time. Again, if somebody wants to come to Albany with us, you can jump on the train and we can do it. So let us know, even following this, if there are questions that come up, please reach out. Mary and I talk about this all the time. We realize that many of you don't. So if you feel like there's sort of more you want to hear about, just we're happy to do so. So maybe if everybody.
What would the require, as a model manager, being in that business for years, is there a way of joining your AMA?
No, the way that we have structured our trade organization, it is for representing creatives within the industry, not who are actually performing the work, not in front of the camera, but behind the camera and on those sides.
Okay.
So that is not currently part of the way our bylaws are set up. But we'll take donations. So, but certainly working together on initiatives and programming and educational stuff, we're more than happy to be partnering. So,
Thank you.
all right. Well, I think we'll let everybody get back to finishing their days, if that's it.
All right.
Thank you guys all for joining us, for coming.
Thank you.
Thank you, Vanessa.
And,
Really great.
sure.
Thank
Guys,
you. Mary.
nice to see you all.
Vanessa.
Thank you.